Welcome to the Court of History. I'm Sidney Blumenthal. I'm here with my colleague, Sean Wilentz of Princeton University, historian. And the Court of History, which is the highest court, delivers the ultimate judgment, is at the nexus of law, history, the Constitution, and current events. We're here today with an extraordinary group of experts to discuss one of the most important subjects that faces our government and our people, and that is information and what we know and how to keep it about what our government has done. It is about the right of the American people to know, which is codified in our law. I'm here today with Jason R. Barron of the University of Maryland, professor of practice. But even more than that, he is the co-founder of the Center for Archival Futures, and he was the first appointed director of litigation at the National Archives and Records Administration. He also served as a trial lawyer and senior counsel in the Civil Division of the U.S. Department of Justice. And we are joined by another authoritative expert. I'm so used to saying
it's on people's minds. You can't help it.
I understand.
Always comes to your head. But Lauren Harper is Freedom of Press Foundation's first Daniel Ellsberg Chair on Government Secrecy. She had previously worked for the National Security Archive as the public policy director and helped historians, journalists, and the public win the declassification of historically significant government documents. And now we are facing perhaps the greatest crisis in our nation's history regarding retention of records and the public's right to know. So I'd like to start with Jason and give us a little history about the creation of the history of the National Archives and how public presidential records were treated prior to President Richard Nixon's abuses of power, which gave rise to the enactment of the Presidential Records Act of 1978. I know we could all learn from an hour's historical lecture on this, but this sets the stage for our further discussion. Jason.
Thanks so much, Sidney and Sean, for inviting me onto the program. The National Archives was created in 1934. It was subsequently consolidated with the General Services Administration, but it became an independent agency again in 1984. The mission of the archives is to strengthen our nation's democracy through preserving and providing equitable public access to government records of permanent value. Everyone thinks of the archives as the Charters of Freedom, the Declaration of Independence, the Constitution, the Bill of Rights that are in the rotunda, but actually there are billions of records in both paper and electronic form, including emails and anything under the sun that relates to government business. And under the law, the archivist of the U.S. is to be appointed without regard to political affiliations and solely on the basis of professional qualifications. So we might get into that. Under the Presidential Records Act, as you mentioned, there's been a change in the history of this country from George Washington up through Richard Nixon. Presidents owned their records. But because of Nixon's abuses of power, Congress passed a special statute with respect to his records and also passed the Presidential Records Act. And so since Ronald Reagan, every president's records, when they leave office, at the moment they leave office, are transferred legally to the custody of the Archivist of the United States. And that law has been in effect from Ronald Reagan through Joe Biden. And the only president who has seriously departed from giving all of his records to the archivist was Donald Trump at the end of his first term.
Well, if you could, give us a little capsule description of what happened, which led to his indictment? And what did he do with those records? And then maybe Lauren wants to jump in here.
Yeah, sure. Happy to after Jason gives us a little background on the Mar-a-Lago situation.
So this was extraordinary. For a year, President Trump, through his representatives, resisted turning over and turning back to the National Archives a sets of dozens of boxes of records. But through negotiations, which should never have taken place, should always have been in the legal custody of the archives, but because of the efforts of archivists and senior officials at NARA, there was an original return of something on the order of 15 boxes. A year after Trump left the presidency, archivists opened those boxes, found classified records, notified DOJ of national security issues raised. And then after that, there were both a subpoena and a search warrant for records at Mar-a-Lago that had been taken by Trump and his people. After that, the special counsel filed a lawsuit under Title 18 of the U.S. Code, under provisions that prohibit the taking of materials, documents that relate to the national security. So essentially classified documents. That lawsuit before Judge Cannon was proceeding until a motion was filed to declare that the special counsel himself was unconstitutionally appointed. And after President Trump's election to a second term, the special counsel shut down his own litigation, knowing that under DOJ policy, it would be very difficult to go on to have a prosecution of a sitting president. So the issues regarding the taking of classified records and any presidential records have not been resolved in that litigation. But it's clear that there was something happening there that was unprecedented.
Lauren?
Yeah, I would just add, the special counsel's lawsuit didn't really address the Presidential Records Act, which may have been an oversight in retrospect. And also earlier this year, we know that the Justice Department returned to President Trump many of the items that were taken during the FBI raid on Mar-a-Lago. Does some of that include the records that were taken? We honestly don't know. I also wanted to add, we often talk about the National Archives in terms of its importance to historical records and older records. That's how most people interact with the agency. If they're researching their family history or their veterans seeking documentation to help claim their benefits, et cetera. But NARA also has a lot of responsibilities that go beyond this and that help us understand our present moment as well. So, for example, NARA also runs the National Declassification Center, which coordinates declassification practices across the government. And it also plays a central role in making sure that agencies are following both their classification rules and that they aren't improperly destroying records. So the issue of who's at the helm at the National Archives is a much bigger issue than just, what's going to happen to our historical records. It is an issue in terms of how we, the public, and all the branches of government understand what's happening in our present moment.
Mm-hmm. Yeah, I mean, as a historian, I got to say, I've loved NARA for a very long time, precisely because of its historical function. I mean, to wipe out history down the line, anything that's wiped out now will be wiped out forever. So the fact that we have the evidence there, that's just an historian talking. But nevertheless, I'm trying to think of all the ways in which, Trump seizing these documents and holding on to them, they can have catastrophic potential results, wouldn't they? I mean, there are things in there that could be used in all kinds of ways, I would imagine, against the national interest and perhaps in the interest of the individual who did the taking. Isn't that true?
Well, it's extraordinary that he would consider classified records in particular to be his personal records. That's not what the Presidential Records Act applies for. The only tiny category of personal records consists of diaries and journals and like a personal letter to a family member. Everything else at the White House is about government business and should be preserved for the American people, not for a president. What is worrisome is with an appointment of an acting archivist like Mr. Rubio, who is not professionally qualified within the meaning of the statute, or whoever is appointed and confirmed by the Senate to be the next archivist. The worrisome thing is whether they would stand up to a President Trump, who wants to take even larger quantities of records from the White House and declare them to be his personal records. That is something that one would hope that the National Archives would care about under its mission.
Right. And DOJ, which, as you know, insists that it's a Presidential Records Act entity as opposed to a Federal Records Act entity subject to FOIA. There are also interesting implications here because the records purportedly that DOJ is creating are presidential as opposed to federal. So the issue of whether the acting archivist or whoever might be appointed to the archivist role, and are they going to push back if there are, reports of improper destruction of records, et cetera, is extremely important.
Yeah, Lauren, right now, there's a case that's going before the Supreme Court, and the Solicitor General, Sauer, who was the personal lawyer of Donald Trump, filed a motion yesterday asking the judge to stay his order, which allows discovery, including deposition of the former nominal DOJ director, Gleason, not Elon Musk, to proceed in the FOIA case against DOJ brought by Crew. And this is the result, if you can go through the history of the firing of Colleen Shogan, the director of the archives, and her replacement by Marco Rubio, the Secretary of State, who's now wearing so many hats, he is a personal hat store.
Yeah, he's a haberdasher hat store. Yeah.
Yeah. So if you can tell us the sequence of that recent series of events that have led to this legal standoff.
Yeah, happy to. I'll dig into kind of the creation of DOJ, and then perhaps we could talk about a little bit more explicitly about the firing of Dr. Shogan. But early on in this administration, the president issued an executive order establishing the Department of Government Efficiency. And it was basically stated in the executive order that DOJ was going to be created, or a repurposed version of an entity that already exists called the United States Digital Service, USDS. Now, USDS existed previously to this administration as a component of the Office of Management and Budget. Now, OMB is a component of the Executive Office of the President. And often the way it's talked about is that if you're a component of the EOP, the Office of the President, you're subject to the Presidential Records Act and not subject to the FOIA. But this is not strictly true. OMB was subject to the FOIA. Other entities like the Council on Environmental Quality, the Office of National Drug Control Policy, and a few others are entities within the EOP that are subject to FOIA. But this executive order came out and basically said, no, DOJ is going to be an advisory entity, sort of like the National Security Council is an advisory entity, at least in theory. And so it won't be subject to the FOIA. Instead, it will be subject to the Presidential Records Act. Now, the Presidential Records Act does have a provision that FOIA does become applicable, but not until 5 years after the end of a presidential administration. So this basically means that DOJ records won't begin to be public until 2034. There were immediately lawsuits filed by organizations like the one at issue in the Supreme Court case, the Citizens for Responsibility and Ethics in Washington, that challenged this and said, no, DOJ and their representatives are playing an active role in terminating agencies and agency personnel across the government. This clearly is not advisory. It's clearly operational, so it should be subject to FOIA. And Judge Cooper in the lower court agreed initially and said it seemed as though DOJ is likely subject to FOIA. The government is strenuously disagreeing and is basically saying that no, Doge itself and Amy Gleason, their director, are advisory, but the agency Doge teams that are set up within, let's say the State Department, the DoD, wherever they are, these are federal employees. They're not actually Doge employees. So their work is not things that we would have access to. And so therefore requests for our records don't include these operational records for issues that are happening in agencies. Our records remain off limits due to the Presidential Records Act. And I'm sure Jason can elaborate on this.
So it seems pretty clear that Elon Musk and Doge are doing more than solely advising and assisting the president. They are making decisions independently of the president in all sorts of ways, either shuttering agencies, halting payments on federal contracts, emailing millions of employees to give 5 things they did last week, and more importantly, a fork in the road email memo offering deferred resignations, and going into databases. And all of these actions, what the discovery request in the Supreme Court deciding on, and what Judge Cooper has allowed, is to have lawyers find out who is in charge, who is directing all of those actions to be taken. And I think there's a substantial record to show that Doge is a federal agency within the meaning of the law, and that its records are subject right now to the Freedom of Information Act.
Yeah, I just want to point out really quickly that in the Judge Cooper ruling prior to that, Doge had said that it would take 3 years to respond to the FOIA request for what at that point were only a couple weeks, like maybe 6 weeks worth of records. So there's been stalling on a variety of fronts in terms of Doge providing transparency around what it's doing.
Yeah, so people think that, particularly the Washington punditocracy, that somehow Elon Musk has stepped back and therefore the effects of Doge disappear. It's no longer, a subject to discuss, but actually it's front and center and crucially at the heart of the assault on the federal government, including on the National Archives. And this lawsuit really has put Doge on the spot and the administration. What do you think, Lauren?
Yeah, no, I absolutely agree. And one of the things that I find so interesting about Doge's creation is that they specifically placed it allegedly as a Presidential Records Act entity. And one of the things that this said to me is that this Trump administration hired some lawyers who were a lot more familiar with federal and presidential records law than they had during the first term. And I think they were able to see, the Presidential Records Act has always been, for lack of a better term, a gentleman's agreement. It's relied a lot on trust and a president's desire to preserve their own legacy and follow the rules of the Presidential Records Act to do so. But I think this administration has realized that they can exploit existing loopholes to be much more secretive than any president in the past. And I would just point out that the executive order that stood up Doge also created an 18-month temporary Doge entity at the same time. And this is important because these lawsuits are going to take quite a bit of time to play out. So there are significant records that Doge is creating right now that fall under the purview of this temporary organization. And so one of the outstanding questions is, if these lawsuits go on longer than the 18-month period, how are we going to make sure that we have access to the records of the temporary Doge entity that was set up by the executive order?
Yeah, what you raise is a plethora of pressing questions, among them the intent of trying to create such an entity on the basis of hiding records. And so what is what state of mind, what could the motive, the intent be to want to hide records? And this goes as well, Jason, to the question of the firing of the nonpartisan director and putting it essentially under Trump's control.
Well, I'd say that the actions Doge and the administration fighting so hard to keep Doge records secret from the American public give lie to the notions of radical transparency that the administration keeps claiming that it is attempting to follow. With respect to Dr. Shogun, she had nothing to do with Mar-a-Lago, and it was absurd on the part of the president to fire a U.S. archivist on presumably that basis. It's also ironic that there were weeks going by where it wasn't clear who was going to be her replacement as acting archivist. And the fact that acting archivist Rubio has other jobs and many other responsibilities is, I think, shows a lack of respect for the mission of the National Archives. Since 1984, when archivists have left office, the deputy archivist, a civil servant employee, and a qualified expert have filled the vacancy. The statute requires that. But here, the deputy archivist was essentially forced out. Mm-hmm. And now we have what is an agency run by someone delegated, but not in the position of the archivist. It is, if I could also say, that Dr. Shogun, in her time in office, showed a great interest in improving the archive's ability to preserve electronic records of the government. And here, in this time where there isn't an archivist, you also have an acting archivist, Mr. Rubio, who participated in the Signal group chat without realization that the group chat itself were records. They're both presidential records of those in the White House who participated on that chat and federal records that are FOIAble. And yet no one seemed to notice not only the presence of a journalist, but the fact that the communications were records themselves. This is a huge issue in terms of the era we're in, which is all about emails and electronic communications being properly preserved. We're not in a paper world anymore. In fact, one more thing that I'll say and I'll stop, which is that the National Archives in June 2024 essentially changed into an agency that from that date on would only accept electronic or digital copies of records and not paper anymore. No more paper coming into the National Archives except as a legacy matter. This is a sea change, and the world we're in going forward is an archives of electronic records that needs to be dealt with by a serious U.S. archivist and supported with the resources given to NARA to continue to do its mission in a digital age.
Could I add 2 quick points?
Yeah.
Please do.
Yeah. So, we're talking about Doge's secrecy, but I think it's really important to talk about the fact that this is not happening in a vacuum. This is happening at the same time that Doge is encouraging, along with federal officials like RFK Jr., the mass firing of FOIA offices, which makes it much more difficult to get information out about federal records. We're also seeing agencies take down thousands of data sets. We are seeing inspectors generals being intimidated from releasing reports. So it's an all-out assault on the right to information. And I think the end goal of the Trump administration is to really make the Trump administration, their political appointees and so on, the sole source of information coming out of the government, even if that information is not necessarily accurate. I think we can look to the invocation and the rationale behind the invocation of the Alien Enemies Act, as example. But in addition to Signalgate, Marco Rubio is also the acting administrator of the U.S. Agency for International Development. Earlier this year, the USAID tried to burn classified records. And Marco Rubio did not appear to put up a fight, even though he had a responsibility as the acting head of USAID to stop the unlawful destruction of records. As the head of USAID's successor agency, which is the State Department, and as the head of the agency that's supposed to investigate the unlawful destruction of records, the National Archives, he didn't do anything in his capacity in any of these roles to stop the unwarranted destruction of federal records. And I think if you apply this out to any agency that's destroying records, we have a lot to be concerned about with Marco Rubio as an acting archivist not standing up for the preservation of records.
Well, you raise an interesting question about USAID. I have firsthand knowledge talking to a former USAID employee who told me before he was fired that Doge came in and systematically attempted to and has been destroying records in part so that the agency itself can never be reconstructed. And people don't know what the practices were in the past. So when people think of records, they're not simply for historians to write, but also we're going to be engaged in this country if and when the Trump administration is over in a grand new reconstruction effort. And they are trying to prevent that right now through the destruction of records. And I want to raise these other questions also for you and Jason of the relationship, as you've raised, Lauren, to intelligence gathering. We're now engaged in the suppression of intelligence and the destruction of intelligence records or hiding and making them secret and even distorting them. We now know that under the Director of National Intelligence, the intelligence community was informed that it should create false information that relates to the Enemies Alien Act and Donald Trump's emergency executive order on the notion that a Venezuelan gang, Tren de Aragua, is coordinated by the Maduro regime of Venezuela, which the intelligence community has stated is false. And they were told to rewrite it on the basis of being congruent with Trump's falsehood. And that will involve the destruction of records. And then there's the entire question of all scientific research, which Robert F. Kennedy is now in distorting or suppressing or wiping out in the interest of his crank ideas. And there's a massive destruction of scientific research and records going on right now, not only under his purview, but others in the administration. So I wonder if you and Jason can address, that's a lot to digest, but those larger questions that relate to everyone's lives, from national security to public health.
Yeah, I'm happy to jump in because my FOIA request for the Tren de Aragua really helped bring about this story. But I do want to underscore your point that one of the problems with destroying agency records is it makes it nearly impossible for any future administration to rebuild what this one breaks. I think that's a critical point for us all to remember. In terms of intelligence, the Trump administration on March 15th issued an executive order invoking the Alien Enemies Act to deport members of what it purported to be a Venezuelan gang called Tren de Aragua. And to do so, to invoke this act, they had to draw a direct connection between members of the gang and the Maduro government in Venezuela, because the way this 18th century law is written, there has to be a foreign government involved. For example, you can't use it to deport people who are supposedly affiliated with an independent organization like a gang. There has to be this connection to a foreign government. So the Trump administration invoked the Alien Enemies Act and said, these folks are all connected with the Maduro government. They're directing their activities and so forth. Shortly after that, on March 20th or so, the New York Times issued a report, a news article based on leaked information that said that there was a national intelligence community assessment that directly contradicted this claim. Tulsi Gabbard was furious, the director of national intelligence, Tulsi Gabbard, she was furious. She opened criminal investigations into the leaks of this material. Sometime later in April, the Washington Post reported on another national intelligence community assessment that also directly contradicted the Trump administration's invocation of this law to deport people. And so I saw this and, I thought that would make a good FOIA request, but I didn't file a FOIA request until Pam Bondi, the Attorney General, cited the Washington Post and the New York Times reporting as both an excuse to open criminal investigation into the leaks, but also to revoke Merrick Garland era protections for journalists. She basically said the leaks of this information were dangerous and they made it harder for the Justice Department to protect the country. And I remember thinking, absolutely not. This is exactly the kind of information that should be released, because we can't use classified information to hide information that's embarrassing or conceals wrongdoing. And so I filed a FOIA request for this document, this assessment that contradicted the Trump administration. And to my surprise, 7 days later, the document was released through FOIA. And if you've ever filed a FOIA request, this is absolutely unheard of. It's ridiculously fast. And I speculated, I had my own theories about why it was released so quickly. I thought, perhaps FOIA offices are being gutted. Perhaps this was being leaked as a quiet dissent before the office gets downsized. I thought perhaps it was a mistake. What I did not anticipate was that Joe Kent, who's Tulsi Gabbard's chief of staff, pushed for this document to be declassified because he thought inconceivably that it proved the Trump administration's rationale. So it's concerning that Joe Kent, who's also the nominee to lead the National Counterterrorism Center, can't read an intelligence report. But it's equally concerning that we know, thanks to reporting, that Joe Kent pushed for the National Intelligence Council to reproduce this assessment in a way that couldn't be used against, and this is a paraphrase, but pretty close quote, couldn't be used against Gabbard or POTUS. So we see the intelligence community officials very likely pressuring the creation of intelligence that's favorable for the president. Now, this is really important because Gabbard has also taken increased control over the production of the president's daily brief, which is the most sensitive intelligence document there is in the U.S. government. And there is a real danger to producing a PDB that responds to Trump's worldview and what Trump wants to hear, as opposed to a more objective reality. This makes us all less safe.
Yeah.
I mean, the manifold. Go ahead. I'm sorry. Jason, go ahead.
Can I just jump in to underscore all of the points that Lauren made and bring it back to the National Archives? In a normal administration, the National Archives has the power to open its own investigation and to make a referral to the Justice Department if there have been some finding of destruction of records anywhere in the executive branch. However, here, not only would one anticipate that those referrals are not going to be made in the first instance, but if they land on Pam Bondi's, the Attorney General's desk at DOJ, I'm hard-pressed to think that there will be the kind of investigations and going forward with litigation to recover documents or to change policies or to discipline in any fashion or even indict individuals for their actions. And so the scheme, the guardrails that are there, the legal framework is potentially going to be ignored. And we should all be concerned. There were reports of special counsel Jack Smith's report not being permanently preserved. There are questions about the preservation of many important documents that would otherwise be considered permanent records of the United States going to the National Archives that are in danger of not being preserved without any kind of enforcement action on the part of DOJ.
Yeah, Sean, you had a question.
Just to pull back though from the details. I mean, this is Orwellian, isn't it? I mean, it sounds to me as if when you add it all up in terms of both current policy and history, that they're trying to establish the Ministry of Truth, and that's what it comes down to. And so for people who are not necessarily up to snuff about the law, that's the reference I think that we have to think about, that they are trying to control what in fact the truth actually is. And this is happening in a lot of different realms. We know about it from social media, et cetera, et cetera. But this is the government itself. This is establishing an effect. I mean, there won't be a minister of truth probably, although who knows? It'll probably be Marco Rubio because he has all the other jobs, But that's what they're actually trying to do. There's also an interlocking aspect of this between, it's not just what's going on inside the White House. For example, looking back on the decision to the Mar-a-Lago business, and the way in which Jack Smith was denied, and the whole idea that the special counsel might be unconstitutional and so forth. As I recall, that came from a dissent that Clarence Thomas made in importing a rather crackpot right-wing idea about the special counsel law, and then it went directly on to Eileen Cannon's decision. In other words, this is not just some overeager people at Doge doing all of this. This is systemic, is what I'm saying, and that is what it has to be brought out as well. That this is not just something that's going on because of a small group of people who are going overboard, but rather it is the policy of the Trump regime to establish this ministry of truth. And it includes people like the members of the Supreme Court, not all of it, members of the Supreme Court. I'm sure people in the House of Representatives. I mean, I don't want to go into a vast conspiracy theory, but the fact is this is what's happening, right?
Yeah, I couldn't agree with you more. And the amount of doublespeak that we're also seeing on topics like transparency gets to that very same point.
Yeah.
I would like to say that I understand that this is a very dark time. You can fire FOIA staff, but you are not getting rid of the Freedom of Information Act. And I would like to think, and I hope I'm not naive in this, that there are many federal judges who are going to uphold at least the laws with respect to the record-keeping laws and the access laws in ways that will push back on what the administration is attempting to do. I think President Trump and his people are trying to control history in ways that we've never seen before, but I think there are too many records and that they will eventually not succeed. It may take time after this presidency is over, but there will be a historical record for us to look at and evaluate the actions of this presidency.
I think Jason makes a really good point. The judiciary in particular has a lot of bright spots right now, especially if you're comparing it to what we're seeing out of the executive and the legislative. I think Jason's right to be optimistic on that front.
Well, let's hope so. I want to thank you for appearing on the Court of History, which is the highest court. I wish we had more authority, but we do have authorities here. I want to thank Jason Barron of the University of Maryland, Professor of Practice of Information, and Lauren Harper, Freedom of the Press Foundation's Daniel Ellsberg Chair in Government Secrecy, and of course, my colleague, Sean Wilentz of Princeton. Thank you all.
Thank you.
Thanks.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.